judicial interpretations and regulatory updates. So here we will discuss the evolving judicial interpretations in IBC, as well as what are the latest updates, regulatory updates from IBBI. So I'll just start with opening remarks. The primary objective of the IBC is to consolidate and amend existing insolvency laws in India. That means there were many insolvency laws and there was no consolidated code for the insolvency laws. So IBC is a code which has consolidated and amended all the laws, existing laws of insolvency in India. And the main objects are time-bound, efficient process of resolving insolvency and bankruptcy cases for individuals, partnerships, and companies. The code also aims to maximize the asset value, promote entrepreneurship, and ensure a balance between interest of all stakeholders involved. So with this object, the IBC code has come into existence, and the evolving judicial interpretations and the regulatory updates from IBBI has helped the code in successful implementation of the code. So we'll just go through the latest evolving judicial interpretations and regulatory updates from the IBBI regarding the IBC. So when we come to judicial interpretations, we have a very important word that is called precedent. Just yeah, 1 minute. I'm sharing my screen. Yeah, it's coming. So what is precedent? So precedent is a previous instance of a case which furnishes as a rule or an example for subsequent conduct and pattern upon which a subsequent conduct is based. Here, the precedent is setting an example for subsequent conduct and a pattern. That means in implementation of the code, there were many lags where insolvency professionals, the stakeholders were facing a lot of issues, and there were a lot of chaos when the process was going on, and the stakeholders got affected and they moved to NCLT, NCLATs or Supreme Court, and where a example was set for the subsequent processes. So this is called as precedent. The precedent helps in interpretation how the future pattern of the process should be conducted. So when we see the elements of the precedent, there are two precedent elements. One is concrete decision and second is abstract decision. So concrete decision is binding on all the parties and abstract decision is binding on another principal or judge, like Supreme Court judgments are binding on the lower courts, NCLT, NCLAT or High Court. So we'll discuss why precedents are critical in IBC. So when any new law comes into existence, practically it is dealing with larger stakeholders, like insolvency bankruptcy code is dealing mainly the stressed assets, NPAs of the banks, financial institutions, and in the system, stressed assets in the system. So when the process has started, it is affecting large number of stakeholders. So when the process is going on and when the CIRP or liquidation or personal insolvency, bankruptcy process or pre-pack, whatever is getting in the market, when it is being implemented, there are larger issues which have come, like promoters faced issues and the creditors faced issues, the insolvency professionals faced issues, the market faced issues, creditors, bankers faced issues, operational creditors faced issues, employees faced issues, statutory authorities faced issues. So to put a check to these kind of issues, the party stakeholders moved to the judiciary, and the judiciary has set some rules or the processes by which the IBBI also took it up and brought in amendments, and the precedents are used by the lower courts like NCLT, NCLAT for the future cases in similar kind of facts or on a law position. So why IBC's precedents are critical in IBC means the precedents always play a crucial role providing clarity, consistency, and predictability in its application. So while applying any issue related to the implementation or related to any issue, so the precedents will act as a consistent clarity providing how it has to be applied, and the precedents will ensure that fairness in resolving the issues in insolvency cases are fairly resolved. Then particularly Supreme Court, NCLAT, they clarify and guide how code is to be applied in various situations, and that too in a consistent way, And we have seen in last 9 years, IBC is 9 years old, close to 10 years now. The IBC jurisprudence has resolved many issues and the code is getting implemented effectively. Like we'll take up various cases where precedents are set and the things are carried out smoothly. So when we see IBC is close to a decade and this was affected, which this has come into effect from December 2016. And this has significantly impacted the resolution of stressed assets, and it has played a crucial role in the health of banking sector, addressing the NPA assets so that the capital is available in the market by resolving the stressed assets. If we see the latest IBBA report, the creditors have realized close to 3.89 lakh crore under resolution plans till March 2025. And in closed liquidations, the creditors have realized close to 9,330 crores, which is nearly 90% realization as against the liquidation value. So when we see the evolution, the code has delivered an impact far beyond the conventional metric for credit realization. The code has established a robust legal framework, and this has strengthened the credit markets, fostered the entrepreneurship, and significantly enhanced the India's ease of doing business parameters recent past. And because of the GST and the IBC code, the ease of doing business, the number has come down in the parameters which is published. And the improvements have created more conducive environment for investment, ultimately, which drives the economy and development. Although challenges persist, including process delays, recovery rates are below expectations, the code's strong foundation structure remains still sound. So even the implementation is maturing and jurisprudence is evolving. Now almost the IBC is well positioned to overcome the hurdles and also transforming potential in India's financial ecosystem. So with this brief background, we can just take up few landmarks briefly, and the previous landmarks like SBI versus Videocon case, where consolidation of group companies, we have a complete set of precedents from the court. And SR Steel case, where the waterfall mechanism and undecided claims not to pop up after the approval of the plan and commercial wisdom of the COC. These all standard, the waterfall mechanism, commercial wisdom, and the compliance, all these which is like a heart and soul of the IBC are clearly laid down in SR Steel case. And in the DBS Limited versus Ruchi Soya, the rights of dissenting secured financial creditors, the principles are laid down here. And in Swiss Ribbons case, the case has upheld the constitutional validity of the IBC, where the distinguishing between the financial and operational creditors and the differential treatment under the code. So various multiple litigations were filed for the differential treatment between FCs and OCs. So the Swiss Ribbon case has put full stop for the issues between the financial and operational creditors. And Pioneer Urban Land and Infrastructure Limited versus Union of India. This judgment also classified home buyers as financial creditors by giving them a voice in the COC and ensuring their interests are considered during insolvency proceedings. This is one of the landmark in the home buyers cases. The home buyers are classified as FCs. Now they have the voice in COC through their authorized representative. The next tomorrow's speaker will take up about the authorized representative case laws. And the Lalit Kumar Jain versus Union of India. Here, this is a landmark case for the personal insolvency matter, where when the personal insolvency was notified and when the cases were getting admitted, the multiple writ petitions were filed, and the Supreme Court in this case has held that the personal guarantor's liability is not discharged by the approval of a resolution plan for the corporate debtor. Then we have Jet Airways case where clarity has come for the EPFO claims. It is separate from liquidation estate and cannot be treated pari passu along with the other creditors, and EPFO claims had to be paid in priority. So with this, just a brief background on few landmark cases, we can go to the recent case laws where some of the precedents are set. One is Independent Sugar Corporation Limited versus Girish Sriram Juneja. So this is the latest Supreme Court judgment where the judgment was delivered regarding the interpretation of section 31(4) of the IBC. See, ordinarily, necessary approvals are required under any law are to be obtained within 1 year of approval of the resolution plan. So this is part of almost all the resolution plans. But however, an exception was there in case if the resolution plan is giving for a combination as per section 5 of the Competition Act. This needs to be approved prior to putting up for the voting for approval of COC. So this exception came into force by an amendment under section 31(4). So some exceptions were provided here. So when we see the latest Supreme Court judgment, the concerns raised here are mandatory nature of Competition Commission of India's approval for resolution plans. Here, 3-judge bench in the majority of 2:1 in January 2025, they affirmed that Competition Commission of India's approval must be obtained by the RP before the COC votes on a resolution plan. So here the decision has clarified section 31(4) of IBC is mandatory and it is not directory. That means the CCI approval is a prerequisite for prior COC approval. So when we see here, the Supreme Court has emphasized that COC can vote on a resolution plan only after mandatory CCI approval. And the ruling again acknowledges the importance of the COC's commercial judgment, but also recognizes the potential for anti-competitive transactions within resolution plans. So, excuse me. So if there are any anti-competitive transactions within the resolution plans, the Supreme Court is acknowledging the importance. Even prior commercial COC's approval, CCI approval is mandatory. So what happens here after this decision? So usually what was the practice is after the COC approved the plan, CCI approval was to be obtained. So this is the general practice in the market. But now with this ruling, CCI approvals has to be taken prior to COC approval. So the Supreme Court again clarifies the approval must be, the competition concerns must be addressed early in the process. So here, if we see, the implications would be timelines of the resolution process, the lengthening of the process. So the mandatory consultation with CCI requirement will, it may lead to not complying the stricter timelines. The object of the, one of the object of the IBC is timely resolution. So this may have an impact. Since it is a latest judgment, we'll see how the market evolves in this regard. So here, if we see, this ruling has introduced more stringent process for resolution plan where CCI approval is required. For the complex cases, the CCI may also take some time. Potentially, this may delay the process. So, any hope I am clear. Then we'll have one more latest important case law is Pyramid Capital and Housing Finance Limited versus Moons Technologies and others. Here, DHFL is a housing finance company which is regulated under RBI Act and the National Housing Bank Act 1987. And this company, DHFL company, has faced allegations for financial fraud involving thousands of crores of rupees. In 2019, RBI has superseded the DHFL's board of directors under Section 45(1)(e) of RBI Act. And they have appointed Subramanya Kumar as administrator. And RBI has initiated CIRP under IBC. Here, I just want to make it one thing clear to the participants. See, whenever the companies which are governed by either SEBI or RBI, the financial creditors cannot take up directly, they cannot proceed and file the cases against the corporate debtor with NCLT under section 7, 9 or 10. They have to get the go through the route of RBI and SEBI respective authorities. So in this DHFL case, as they were registered under RBI and NHB Act, RBI itself has initiated the IBC case against DHFL. So the case was admitted and administrator is appointed. So when SEBI appoints, SEBI or RBI recommends, they are not called, although they are empaneled insolvency professionals, they are not called as resolution professionals. They will be called as administrators. But they will do a role and they have a role and responsibilities like a RP only. And they have to comply with the IBC code. So RBI initiated CIRP under IBC and the NCLT admitted, and the COC comprised of banks, financial institutions and the FD holders and NCD holders. And here the resolution plan was submitted by Pyramid Capital and Housing Finance Limited, and this was approved by a vote of 93.65% votes. And the resolution plan applicant has offered 37,250 crores in this plan. But after the approval of the plan, here disputes arose on three key issues. One is the treatment of recoveries from the avoidance applications under Section 66 of the IBC. And the distribution mechanism for fixed deposit holders and NCD holders, and the rights of ex-promoters to participate in the CIRP process. So these are the disputes which arose and which are being settled. Here the NCLAT on 27th January 2022, they modified the resolution plan. They directed the COC to reconsider the appropriation of Section 66 recoveries by Pyramid Capital. So this led to multiple appeals before Supreme Court, and they have been categorized the issues into 3. And then the matters are dealt in category wise. The legal issues categorized into 3, and they are being dealt. One is regarding the avoidance transactions and COC's commercial wisdom. So here what has happened is the COC agreed the successful resolution applicant, that is Pyramid Capital, to keep the recoveries from avoidance transactions that is worth 45,050 crores in return for a higher upfront payment. So here the successful resolution applicant is paying more higher upfront to COC, and COC is agreeing that the proceeds from avoidance transactions will accrue to the successful resolution applicant. So here NCLAT disagreed with the deal, and so see, NCLAT said that this cannot be. The creditor should be the beneficiary of pyramid, not the SRA. The COC should be the beneficiary of avoidance transactions. But Supreme Court reversed, and they have upheld the COC's commercial decision. And they said the commercial wisdom of COC cannot be easily challenged until it is completely unreasonable or illegal. So here COC has said that the Supreme Court has said that COC's decision must be respected with minimal court interference. See, they have some benefit of higher upfront. So for which they agreed that the proceeds from avoidance transaction should accrue to SRA. So again, what is the main object of this order by Supreme Court in the first issue of avoidance transactions is allowing recoveries under Section 66 to RA is valid if it is part of resolution plan and approved by COC. Here it is encouraging value maximization and faster resolution. That means value is maximized for creditors and the stakeholders, and resolution is achieved in a faster way, which is again the main object of the IBC. Then it comes to second issue in this DHFL cases, rights of fixed deposit and NCD holders. So here if we see few fixed deposit holders and NCD holders which were part of the COC, they objected that they didn't get full repayment. Only the depositors who were below 2 lakhs, they got full payment, and others got in proportionate to the share of their liquidation value. And here, sorry, here the FD and NCD holders, they said that they are covered under NHB Act, and RBI Act gave them full repayment rights. So Supreme Court clarified no law promises full repayment to creditors, and the distribution among the creditors which is approved by COC is legal. And once the COC plan is approved by majority with the requisite voting percentage, all creditors including FDs or NCD holders must follow the decision. And as per Section 31, the approved plan is binding on all the stakeholders. So part of FD and NCD holders voted for this plan. So when majority has voted, then they cannot come and question the decision and they cannot disagree. This is the second legal issue. Then when it comes to rights of ex-promoters to participate in the CIRP, the former promoters like Kapil Wadhwan and Dheeraj Wadhwan, they wanted to attend the COC meetings and access the resolution plan. So I want to draw the attention of the members here. Here, the directors are not in the usual course of CIRP, their powers are not suspended here. So RBI has removed the directors and directorship was permanently removed under RBI Act. They were not like suspended directors under IBC. So their directorship was removed by RBI under RBI Act. So they had no legal right to attend the COC meetings. So once RBI removes the name, they lose the right to participate. So here one more, I want to share my practical experience. In my case, one of the Karvi group, I was the resolution professional and the promoter of the Karvi group, there was an order from SEBI restraining him to be a director on any of the SEBI registered intermediaries. So and the order was challenged and there was no order on that, whatever grounds he has challenged, there was no order on the SEBI. And the SEBI order was intact and he was restrained to be a director. So I didn't invite him to the COC meetings. He went and filed an appeal before NCLT. Then NCLT said that once your directorship is removed or if there is a restraint order from any regulators, then RP was right in not inviting you to the COC meetings. You have no legal right to attend the COC meetings. So here we need to ensure in case if there is any restraint order on the director or any like RBI, SEBI or any authorities restrain them for being a director, then they are not supposed to attend the COC meetings. So they cannot be part of CIRP process. So whatever documents, if they want to view, they can ask for it. But again, it is not their legal right. So the basic principles which were upheld here is COC decision is final and there was a clarity on avoidance transactions. It is a commercial decision. And if COC decides that recovery should go to creditors or SRA and approves the plan, then that is final and binding. And stakeholders must follow a collective process. It's a rights and rem. And the collective decision is binding. And when the majority takes and the decision and votes, they cannot challenge individually on the collective process. So court will have to stay out unless needed. So NCLT and NCLAT cannot step into shoes of COC or question the business decisions. In this case, NCLAT has stepped into the shoes of COC and they have modified the resolution plan, which the Supreme Court has held that unless and until needed, NCLT and NCLAT cannot step into the shoes of a COC. So we have covered two cases and we have been discussing the previous precedents. Any questions, sir, so far? So we'll go to the next case law, that is Jana Seva Sahakari Bank Limited versus Ravindra P. Berole. Here, successful resolution applicant has breached the terms of an approved plan and the adjudicating authority is obligated under section 33(4) that the liquidation order is the final outcome. Just 1 minute. I'll just take one call. Give me 2 minutes. Hello. Shravan. Yeah. Sorry. So in this Janaseva Sahakari Bank Limited, the SRA has breached the terms of the resolution plan, and the as per the section 33(4) of IBC, the adjudicating authority has to pass a liquidation order. Here, the ruling came when Janaseva Sahakari Bank, a secured creditor in UTech Engineering Works, they have filed for a liquidation order. See, even despite approval of the plan, the SRA here failed to adhere to the agreed payment timelines and also obligations. Here, the sole secured creditor has alleged continuous non-compliances. See, what has happened here, the applicant cited multiple issues. See, what SRA had submitted in his cases, he said he has delayed in payment, which is again due to unforeseen challenges and severe loss of goodwill of the corporate debtor, because of which operational continuity was not, he was not able to get the renewing of the licenses, and due to CRP status, he corporate debtor operations were stalled. But however, COC has cited multiple breaches. Here, COC said that the entire CRP cost was to be paid. He has failed to pay that. And the first tranche was due in April, again in 2022, but he made after 1 year. And improper adjustment of CRP cost from subsequent payments. Again, this led to shortfall. And non-payment of second and third tranches respectively. He has not paid second and third tranche also. He continued to make payments for the working capital term loans which were funded. And he was defaulting to the statutory creditors. He was not discharging the statutory creditors also. He was not paying the GST, ESI, PF, whatever statutory dues, statutory claims. The applicant also, here the applicant is the bank, they have highlighted that they have been giving multiple opportunities, multiple reminders, and they tried to cure the default. They have given lot of opportunities to SRA, but SRA was non-responsive, and they, in good faith, the creditor has given many extensions. In spite of that, he was not responding. Even SRA has given assurances, but he was not honoring his whatever assurances he was giving to the bank. So,
Madam, SRA, what is the?
Sorry, successful resolution applicant, sir, whose plan
Okay.
by NCLT.
Okay.
So the successful resolution applicant has admitted there was a delay in the payment, and he said these are all unforeseen challenges which he has been facing due to dormant business and the goodwill, severe loss to the goodwill and operational continuity was affected. And there were a lot of constraints which he was facing while implementing the plan. Although he has infused some amount towards the corporate debtor obligations, he has not done anything in bad faith, but he requested for a lenient view. But however, after going through the submissions and the review of the facts, the tribunal held that a successful resolution applicant had clearly failed to implement the plan, and the bench has passed for liquidation order. Here, Supreme Court again quoted ArcelorMittal and recent Bhushan Power Steel case, which again emphasized that strict compliance of the resolution plans, and it has clarified that the bank has given enough opportunities and a lenient view were taken many times. In spite of that, there was breach of plan which is unwarranted. So this is regarding the implementation of the plan. Then we have one more case law, which is Mukund Chowdhury versus Union, wherein a writ petition was filed before Supreme Court, which was challenging the constitutional validity of Section 101. So this provides 180 days moratorium for the insolvency proceedings against the personal guarantor. Here, Supreme Court has dismissed the writ petition and held that individual insolvency and CIRP moratorium are different. So here the CD will be rehabilitated. So when the moratorium is imposed, the moratorium of personal insolvency was challenged. So here Supreme Court held that the moratorium validity in the personal insolvency process, and they said that the CIRP process moratorium is different and the moratorium under personal insolvency is different. Here for the CRP process, the CD has to be rehabilitated and a resolution plan will be a recourse during the moratorium. Then we have one more important case law, which is Tesalit Limited versus Union of India. This is regarding the payment of gratuities to the employees. So here the successful resolution applicant in their resolution plan has proposed only partial payment for an ex-employee towards his gratuity. So here the ex-employee has filed a case before Assistant Labor Commissioner and Controlling Authority. And Controlling Authority has directed for payment of gratuity along with interest till actual payment. So here the SRA, that is the corporate debtor, has challenged the order of competent authority before High Court of Kolkata. See, again the Kolkata High Court has observed that CD was never closed and gratuity fund was maintained, and the dues of workers are not permissible to be included in the liquidation estate. So the dues of the workers are not to be included in the liquidation estate, like gratuity fund and PF dues. All these are out of liquidation estate, and they have to be utilized only for payment of towards that dues. And such dues have to be paid in full when the fund is available. So the writ is dismissed, and they have held that SRA has, since the CD was a going concern, the controlling authority, that is the Assistant Labor Commissioner, has the authority to decide on the dues of the gratuity of the workers. So this is one of the latest case laws regarding the gratuity. So as an insolvency professional handling the going concern CDs, we need to be very, very diligent, careful when it comes to the gratuity fund or the PF dues. So during the CRP process, you please ensure that if it is a going concern, whatever employees are available, you need to pay towards their PF claims. In case only few employees are there and CD is not a going concern, you may immediately, as per the precedents, you please issue no work, no pay notice so that you will not be held responsible. In one of my case, same thing has happened. I have rationalized few employees' salaries who were in the range of 5 to 6 lakhs per month salary. In my case, the company was a financial intermediary, and many of the top management guys whose verticals were not functioning, they were just simply coming to company, sitting and going. I have rationalized their salary by 60%. So at least 40% of their salary was close to 2 3 lakhs. They went against me. So NCLT said I have issued at least 40%, but they didn't agree. So after 4 5 months, they were agitating and trying to put create issues in the CRP process, and were trying to stall the process, and were trying to create issues with me. So I issued no work, no pay to all of them. They went to NCLT. Then NCLT said RP is right in her capacity. She can issue no work, no pay in case after review of your role. So we need to ensure very, very diligently when it comes to employees in a CD as a going concern, especially their salaries and the fund availability. A detailed analysis of the CD employees, the funds, employee related funds available, gratuity, all those diligently we need to comply as per the precedent set. So this is one of the recent case law, HDFC Bank Limited versus Pratim Bayal, RP of Birla Tires Limited. Here HDFC Bank is one of the COC member who is a dissenting financial creditor. As you all know, Section 53 and also the compliances CIRP regulations, the dissenting financial creditors has to get a minimum liquidation value and to be paid in priority to the other creditors, secured creditors. Hello? Am I audible, sir? Okay. So,
Yes, madam. Yes.
thank you. So, as you all know, Section 53 is the heart of the section IBC, which clearly lays down how the waterfall mechanism, how the distribution has to happen. So dissenting financial creditors has to get a minimum liquidation value, and they have to be paid in priority over the other creditors, secured financial creditors. So here HDFC Bank, one of the dissenting financial creditors in Birla Tires case, what has happened in this case is the distribution mechanism was approved by the committee of creditors. Again, the distribution was based on the security interest in the resolution. So how the creditors are being paid are based on the value of security available to the creditors. But however, HDFC Bank went and filed a case saying that they are entitled to a higher amount based on the voting share. So what happens here, in the CRP process, as you all know, the RP constitutes the committee of creditors, and the voting rights are assigned based on the claim admitted. So HDFC said that they should get more higher amount based on the voting share. So here there was the question before NCLT was whether COC was justified in approving the plan based on the security interest. So here NCLT, what it has observed is Section 34, which was amended in 2019, empowers the COC to consider feasibility, viability of the plan, and also priority and value of security interest while considering a resolution plan. So we see Section 34 and Section 32, 30 subclause 2, subclause B, it provides that dissenting financial creditors are entitled to an amount which shall not be less than the amount to be paid to such creditors in the event of a liquidation. So NCLAT has dismissed the appeal and held that COC has the commercial discretion, and in its wisdom under section 34, they have come out with a distribution criteria based on the security value. So whatever the resolution plan, amount paid, entitlement to be paid to the dissenting financial creditors, again, which was more than the liquidation value. So here NCLAT held the commercial wisdom of COC is right, and they have complied with section 34 and section 30, subclause 2, subclause B, and both the conditions are met, and COC majority has approved the plan. Hence, whatever is approved is binding on all the stakeholders. So we'll discuss one of the latest and most talked about case law. Without this, we cannot, our session will not be complete without discussing Bush and Steel. So anyone wants to share their thoughts on Bush and Steel case? Or after presentation you want to share? So I want all of you to kindly be interactive and ask any questions or share your experience also. Even it will be a learning experience for all of us. So when this is the most important and the controversial case, which I think last 5-6 months we have been discussing Bush and Steel everywhere in IP forums, in IPAs, and among the IP networks. So the Bush and Steel case, where the resolution plan was approved 6 years back, and the resolution plan was getting implemented. The Honorable Supreme Court, on various petitions filed before them by the operational creditors or the promoters, in various writs, the Honorable Supreme Court took up in Kalyani Transco operational creditor case, and they have cited significant gaps in the conduct of CIRP process, like lapses in statutory timelines, deficiencies in eligibility verification of Section 29A, and irregularities in implementation of the plan, and judicial overreach by NCLT or NCLAT. So these are the few things where Supreme Court has noticed all these instances, and they have cited significant gaps in conduct of the process and even in the implementation of the plan, and they ordered for NCLT to consider liquidation of Bush and Steel. Here, if we see in this case, the major issues, non-compliances noted were Section 30 subclause 2 and Section 30 subclause 3, and operational creditors are not dealt equitably. See what has happened here, the operational creditors were not paid prior to financial creditors. Operational creditors were paid after the financial creditors are paid. And avoidance transactions not dealt adequately. The resolution professional has not done his job properly on the avoidance transactions. And the claims which are admitted by the resolution professional during CIRP process were again reclassified by successful resolution applicant as contingent claims. And successful resolution applicant retained the surplus earned during CIRP. Actually, it should accrue to the creditors. So SRA, successful resolution applicant, has no role for the during CRP process. There is no locus standi for him. and successful resolution applicant has delayed in operational creditor payments and RP has not done diligence on section 29A related party. JSW has done through its joint venture through other companies. They have dealt with Bhushan Steel. And NCLT and NCLAT has judicial review. They have overreached. Whatever is their powers, they have overreached on the other authorities like PMLA, ED. So NCLAT and NCLT has issued orders challenging the PMLA and ED. So this is one of the issue. Then COC and RP has not ensured the compliance of IBC timelines. They have not taken extension of timelines. They just simply proceeded in CRP process without taking approval from NCLT for extension of timelines. So this is these are the few major issues. And however, this case has been the the Supreme Court order is being challenged and a review petition is filed before the Supreme Court itself. And this case came up in last week. Then again, today it was posted. So today's outcome I have not seen. Maybe by tomorrow we can see. See, prima facie, the review in the review petition, Supreme Court has prima facie held that the judgment did not correctly consider the legal position which has laid down in the canton of judgments which the bench has noted. In this case, the Supreme Court has noted few judgments. So in review petition, the Supreme Court has held, in the review was filed by JSW and the Committee of Creditors. So Supreme Court prima facie, they held that the judgment did not consider the legal issues and legal position in the canton of judgments which were cited in this case. So they have to consider various factual positions. So they allowed this as a fit case for review and they recalled this matter for hearing afresh. And today the matter was heard in afresh. It started hearing. So we'll see how the review petition will be taken up. This is going to change the complete canton of the space of IBC. Then we have one more Sonali Power Equipment Private Limited. Here, Supreme Court has clarified important issues regarding the MSME Act and how limitation applies to claims before the conciliation. So here, the court has held that the conciliation proceedings under MSME Act, so even claims that would be otherwise time barred can be raised and possibly settled during conciliation. So when conciliation claims are before the conciliation authorities, the Limitation Act does not apply. But the limitation applies to arbitration proceedings. So in this case, Supreme Court has made it very, very clear that limitation does not apply. The claim is time barred by Limitation Act, but it can be revived because it is brought before the Facilitation Council for conciliation. This is only for the MSMEs. So this very important judgment where it has touched upon how disclosures in financial statement impact the limitation period. So the financials, when we show the MSME dues in the financial statements, this might extend the limitation period if the disclosure is seen as an acknowledgement of debt. See, you cannot simply pass an entry in the balance sheet and treat it as automatically as an acknowledgement. So you have to give a proper remarks, notes, auditor's remark. The wordings have to, in such a way, in financials, it should reflect in such a way that Section 18 of the Limitation Act, the wordings which give us the limitation benefit, such kind of notes has to be prepared and recorded by the auditors and the company in the remarks. So here this is a practical option which is available to safeguard the MSMEs in the financial statements. So here we need to see the court has held the disclosure is only for compliance with statutory and regulatory requirements. It does not waive any objections or defenses. So here any particular amount shown does not mean the company is admitting or acknowledging the liability. So whatever is the entry and the confirmation of the debt validity, the companies have to ensure the disclosure language for the intended acknowledgement of the debt. So this again depends case to case basis. Rather than general statement, you have to be very specific. So here the Supreme Court has settled an important legal issue regarding the recovery of time barred payment claim. Just give me a minute. I have to attend a call. Hello. Hello. So here the Supreme Court has settled an important legal issues regarding the recovery of time barred claims by MSMEs. And here the court has held that MSMEs suppliers may pursue time barred debts through conciliation proceedings. So the difference between arbitration and conciliation. So the MSME suppliers now can claim the time barred debts through conciliation proceedings, not through arbitration. And one important thing is for the MSMEs, we need to ensure the language by which the company is updating its remarks or notes to accounts so that a proper wordings are used, not general statements, but case to case basis, how it should reflect as a claim. This is one important case law. Then we have another case regarding the claims after liquidation closure. In Nashik versus Girish Sriram Juneja and others, this is an NCLAT judgment. Hello? Sorry. Okay. So any claim which arises after liquidation commencement date cannot be entertained by the liquidator as per IBC. That means claims under section 7Q and 14B by PF authorities cannot be taken up after liquidation. So whatever PF authorities have to pass an order, assessment orders under section 7Q and 14B, they have to pass prior to liquidation commencement. Anything after liquidation.
Madam, this 7Q and 14B, which act is this? PF Act.
Sorry, actually, I should have mentioned clearly. This is PF, sir. EPF.
Okay.
I'll
EPF. Thank you.
So any So any claims under section 7Q and 14B of EPFO subsequent to liquidation commencement date, this cannot be taken up. And the adjudicating authority has given an order that whatever claims which the department has submitted after liquidation commencement date, that cannot be entertained. So these are few very latest case laws regarding few aspects I have discussed. So far, any questions regarding the case laws discussed, or anyone want to share anything more regarding the judicial interpretations, evolving judicial interpretations?
Madam, this Nasik versus Girish Siri Ram, you mean to say that because they had submitted the claim late, it cannot be accepted? Is that the fact of the matter?
No, sir. See, here what has happened, the assessment orders have to be passed prior to
Okay.
liquidation commencement date.
Okay.
That means the company was completely under CIRP. So during CIRP, the assessment officer should have issued the notices, and he should have closed the his claim of section 7Q and 14B. That means towards principal interest, principal or damages, whatever during the for the PF claim. So after commencement of liquidation, he cannot come and say that these are my additional claims under 7Q and 14B. See, there should be a specific proper notice issued, and the assessment should be done, and assessment order should have been passed.
Okay.
So this cannot be, the claim cannot arise after liquidation.
That means they have not followed the public announcement given by the IRP, right? The PF department has not followed it.
Sir, if they are not following, and actually, see, they submit the claim, but what here the point is, they should
The order is not made. Okay.
and the claim should have been crystallized.
I know.
See, the claim is again on liquidation commencement date.
Okay.
So when you see the claim is claim as on CIRP commencement date or claim as on liquidation commencement date.
Okay.
So no one can submit a claim after liquidation commencement date. This is my claim.
Okay. Okay.
Should have been crystallized as on liquidation commencement date.
Okay. Thank you. Thank you, madam. Thank you.
Yes. So we have dealt few case laws, recent case laws regarding the IBC in recent few 6-7 months, prior 6-7 months case laws. So the given topic, we have taken up the evolving jurisprudence, judicial interpretations, and now we will go to the regulatory updates. These are all latest ones which I am discussing. So far, any questions regarding the judicial interpretations or any experience you want to share, sir, from the participants? Okay. Otherwise, we'll just go to the latest amendments which have come in the recent 5-6 months. So this is the latest amendment in the IBP, that is under CIRP regulations. 4th July, this is a 5th amendment regulation, which says that this is a regulation 35A 3A. Here, the RP shall mandatorily include in the IM all identified avoidance, fraudulent or wrongful trading transactions. And the resolution plan cannot assign avoidance or fraudulent transactions unless they are disclosed in the IM, and they are intimated to all the PRAs before the final plan date submission. And amendment is done for supporting better price discovery and value maximization of corporate debtor assets. Just 1 minute. So, the latest amendment says that, as you all know, information memorandum is the base document which the RP is supposed to prepare, wherein it is like the complete details of the company, the background, the basic details of the company, about the management, about the directors, and about the activity of the company, about whatever latest financials available, and why the company went into CRP, what are the assets, what are the liabilities, and who are the creditors of the company, the claims received by RP, and what is the business, all these details. And there is a separate regulation detailing what are the contents of the information memorandum. So when RP issues expression of interest, it is his duty to provide to the prospective resolution applicants a virtual data room wherein he will be providing the information memorandum along with all the supporting documents regarding the corporate data available with him, and the request for resolution plan. So this information memorandum is issued by RP to the committee of creditors as well as to the prospective resolution applicants. So this amendment highlights that the information memorandum has to contain the complete details of the avoidance transaction. In case RP has identified a preferential transaction, undervalued, fraudulent, or extortionate transactions, he has to clearly indicate these are the identified transactions, avoidance transactions, and we are going to file the IAs for adjudication. And if the identified avoidance transactions are not there in the IM, then the resolution plan shall not give rights for assigning this fraudulent transaction in future. That means the resolution plan should contain that how this is going to be dealt. And in future, if IM is not providing all these transactions, then the assignment of proceeds of PUFE cannot happen. So this is a amendment which is brought in wherein the better recovery and value maximization of corporate debtor assets. This is very important. So in case any of your assignments, if you have any PUFE transactions, before the resolution plan is put to vote, you include all these details in IM and share it with the PRA. So that tomorrow for assignment of the avoidance application proceeds is smoothly transitioned.
Madam, this amendments are prospective, not retrospective, right?
These are prospective, sir. Yes. With
Okay.
effect from 4th. Suppose you have a resolution plan which you are going to put up for voting. If you have already put up for voting,
Nothing can be done.
4th, nothing can be done. But 4th
Okay.
July, you are launching voting. Then,
All this.
yeah.
Yeah, got it. Got it. Thank you. Thank you. Thank you.
Then there is one more 4th amendment, CIRP regulations, May 26th. This is where majority of the amendments also has come in for the ease of smooth functioning in the CRP process. resolution of corporate debtor in parts. This amendment allows the RPs to invite EOI sale of one or more assets or for CD as a whole with approval of COC. This regulation 36A, there is an amendment. Earlier, we used to issue EOI for the entire assets of the corporate debtor. Suppose if you have any assets which are which you want to the value of assets may deplete or perishable or whatever, there could be some other reasons for multiple reasons. Again, it depends of fact to fact, each case to case different facts you have. So it again depends on the how RP and COC evaluates whether it is better that they can sell the CD in parts or they want to sell as a whole. This option is now allowed. Earlier, this was there in section 28 also. Now, through this amendment, it is allowed. The RP can invite EOI for one or more assets. And during CIRP, interim finance is provided. So, if interim finance is provided, the interim finance providers can attend the COC meetings as observers, since they play a crucial role by providing the funding to the process. This is amendment in regulation 18.5. And there is an amendment in regulation 39, which earlier only the compliant resolution plans were put up for voting. But however, now with this amendment, RP is required to present all resolution plans, irrespective whether it is compliant or non-compliant. He has to put up all the plans before the COC. And payment to dissenting financial creditors. So here dissenting regulation 38.1. So they have to, dissenting financial creditors will now receive at least proportionate share of payment in case of deferred payment and will be prioritized over consenting creditors in each stage of staggered payments. This is for staggered payments. Suppose the resolution plans are beyond 6 months or 1 year. For staggered payments to dissenting FCs, their payment has to be prioritized over consenting creditors. So these amendments keep coming to refine the existing framework so that processes are streamlined and effectively the insolvency issues are resolved. Then we have a third amendment in CIRP regulations on May 19th. This has come into effect from June 1st. This is amendment to regulation 40B, which pertains to the filing of the forms. So earlier we had CRP 1 to 8. Now we have CRP 1 to 5. So this is again a structured format and timelines for submission of these forms, CP1 to CP5. Again, this is through electronic forms. Different phases of CIRP, including like commencement of process, then formation of COC, then monthly updates, then after resolution plan approval, then reporting of avoidance transactions. These have to be filed 10th of next following month. Then we have one more form, CP3B. This is all the orders passed by adjudicating authority in the CIRP process. The RPs are required to ensure filing of this order within 7 days of the order. So delay again, as many of us know, it is again 90 rupees, 500 rupees, 500 rupees every month. It keeps accumulating. I know few RPs who have paid 60,000, 30,000, 40,000 for delay in filing the forms.
So this delayed payment for delayed filing, it is the liability of the RP, is it?
Yes,
so
sir.
to that extent, this fees is getting reduced, right?
Yes, sir. Sir, actually, your IBBI filing fees and all you cannot claim as CRP cost. That is your personal cost.
Okay.
Then we have an amendment on May 19th, that is amendment to personal guarantor regulations. Earlier, RP was supposed to not to take up anything until the repayment plan comes to him. So he has to convene after receiving the claims. He has to convene creditors meeting, and that is with 14 days notice. Then all these creditors at creditors meeting, the personal guarantor has to submit before the creditors meeting. The personal guarantor has to submit the repayment plan. So this used to take time. So now there is an amendment regulation 17A which says regarding non-submission of repayment plan. In majority of the personal insolvency cases, what is happening is there is no repayment plan. Personal guarantors are not traceable. So repayment plan, where no repayment plan is submitted under section 105, the RP can file an application with approval of the creditors. Earlier, if there was no repayment plan, without consulting creditors, RP can file there is no repayment plan. But now with this amendment, they have brought in clear requirement of approval of creditors, even though there is no repayment plan. The RP has to ensure he discusses at the creditors meeting that the fact there is no repayment plan, then submit there is no repayment plan intimating the adjudicating authority and seek appropriate orders. Here, the amendment has come so that the RP is accountable and creditors are also accountable. They consider there is no repayment plan by personal guarantor. This is again the third amendment. Then we come to the second amendment, CRP regulations on 3rd April 2025. So here, very important, as you all know, Form H is the main form which you are going to file with the adjudicating authority after completion of CRP process, even when resolution plan is approved or when liquidation order is passed. Majority of the benches are asking Form H, even though liquidation is recommended by the COC. Some benches are insisting Form H. Form H is like a complete comprehensive record of from commencement of CRP till the end. It covers almost everything. Like you have the CRP timelines. So like that, it covers comprehensive technical all timeline wise compliances of the process. So this is a notable change under regulation 39.4. The IBB has brought in an amendment in Form H where it more transparency. Already we are the IBC, the CRP regulations code puts lot of roles and responsibilities on IP, and we have a IP code also. Again, Form H, we need to be transparent how the process has run. Granular details are captured of resolution plan and what is the timeline, what is the financial impact and how the distribution and what is the realization metrics. Earlier, we didn't have the fair value, liquidation value and stakeholder distribution table. So now these granular details like what is the fair value, what is the liquidation value, how much is the percentage of recovery, they are capturing all this because now IBBI is automating everything. If you put these Form H details into CRP forms, automated, the data gets auto populated and they get the numbers. and even how the PUFE transactions, what is the pending litigations, what is the statutory compliances at every stage, whether you have complied. So this is again standardizing reporting and strengthening the role of RP for compliance. Since CRP is a complexity and regulatory, lot of accountability is there, and even the insolvency is now data driven. To streamline everything, this amendment has brought in. So once if you read the Form H, you will understand how exactly the process has run. And these are the amendments, recent amendments in CIRP. And when we go to the amendments in liquidation, there is a mandatory use of bank net auction platform for liquidation processes. So if you see, this is the latest amendment where the auction platform for liquidation processes is standardized. So earlier the liquidation process was done through various online platforms available. There were 2-3 platforms which the liquidators were using. Now this is streamlined and it is mandatory. So without the using of banknet auction platform, you cannot auction the assets in the liquidation process. This is an amendment through circular on January 10th, where EBKRAY is the auction platform. And this is mandatory where the processes are standardized for the asset sale, for the bidders participation and improve the realization to creditors. Here, all the IPs with effect from April 1st, 2025, they are required to ensure they use this platform along with all the details of conduct of asset and what are the assets which are put up for auction, how the assets are auctioned. Along with it, additionally, all unsold assets in ongoing liquidation cases must also be listed on the platform. So by they gave time up to March 31st. Whoever handling liquidation assignments, they were supposed to list all the unsold assets on the in their ongoing liquidation cases. So here again March 29th, 28th, 2025, additionally one more circular was issued. All IPs to use BankNet for conducting auctions and all IPs to clearly mention in their auction notice that prospective bidders to use the platform and they have to submit the requisite documents and declarations of section 29A also on this electronic auction platform. And prospective bidders shall deposit EMD. See, even the bidders are supposed to deposit the EMD also into this platform, auction platform. So if it is found that an ineligible bidder bids into this platform, automatically the EMD will be forfeited. So this is one of the most effective, as we all know, and we have been discussing the judicial precedents and the what are the latest amendments which IBBA is bringing in. It is all the IBBA and the regulatory and the IPAs, they are all trying to help the stakeholders streamline the process and have complete transparency through digital platforms, as well as they are trying to bring in amendments where any issues faced by the stakeholders are resolved. And for this, IBBA and IPAs are bringing majority of the IPs into the system through consultation papers, and they are trying to have regular interaction sessions on issues. So I feel this is one of the dynamic legislations where many issues in the implementation are getting resolved. So far, any queries or questions, sir? Then we have one more amendment, that is February 3rd to Regulation 4E. This is a very, very important regulation for the home buyers in the real estate projects. This is a very important relief given to home buyers for the stalled real estate projects for enhancing the transparency, accountability, and efficiency in the CRP process. Here, home buyers are allowed now to take possession of their flats with 66% COC approval. Now, home buyers can take the possession of their flats and go for registration with 66% approval. And here, facilitators are now assisting large home buyers in CARP decision making. And now, amendment has brought in that RERA officials, the RERA officials who are the statutory regulatory authorities in real estate projects. Since IPs were facing lot of issues and RERA officials were not able to understand or follow and cooperate with the IPs to support the ecosystem, now the amendment brought in and RERA officials can now attend the COC meetings for better compliance and quicker approvals in the real estate projects. Here, RPs are required to submit reports within 60 days about the developmental rights and approvals in the real estate projects. And more flexibility in resolution plans are given. Home buyer associations can now adjust bidder eligibility criteria and request performance security exemptions. So this is regarding the resolution plan performance security exemptions. Home buyer associations can decide on this. And a monitoring committee will oversee the execution of approved resolution plan and track progress. Stricter implementation and monitoring committee code is the regulation provides for stricter monitoring committee in this real estate projects. Since the home buyers uncompleted projects are involved. Then we have amendment in January to IPA regulations. This IBB is notified on January 28th. So here the timelines are relaxed for submission of application for renewal of AFA. So existing, we were given a window of 45 days before the date of expiry of previous AFA to 90 days. This has relaxed the timelines. Earlier, we were supposed to submit for renewal of AFA for before 45 days only. So now they are giving a window of 90 days. This relaxed timelines will help for approval of AFA for issuance or renewable. So now the window will be opened before 90 days for renewal of AFA. Then we have an amendment to voluntary liquidation process regulations. See, we have been noticing in some of the case laws, in some of the practical issues, when during the voluntary liquidation process, if there is a uncalled capital and that until the company calls for the capital and it is subscribed, we cannot excuse me. So the company cannot go for dissolution. I think this is a different slide which has come. Okay. So there's one more slide. I think it is missing in this slide. I'll try to add. So the latest amendment which has come to the voluntary liquidation process regulations is the uncalled capital. Let me just open the amendment. My screen is visible.
Yes, madam, it is visible.
Thank you, sir. So this is an amendment which has brought in liquidator to realize uncalled capital or unpaid capital contribution. So this is omitted. This has come on 28th January 2025. So earlier the amendment was the liquidator shall realize any amount due from any contributory to the corporate person. That means if you want to go for distribution and go for dissolution of the company, you have to call for that uncalled capital, unpaid capital contribution, then only you should go. So there were a lot of issues which liquidators were facing in the voluntary liquidation process. Now this has been omitted. See, earlier it was no distribution shall be made unless he makes his contribution to the uncalled capital. So now this regulation 33 is omitted. Then in January 28th, 2025, there was one more amendment regarding the maintaining of separate account with the scheduled bank to formalize the voluntary liquidation process. And mandatory, one more important is mandatory filing of voluntary liquidation forms. So earlier there was no voluntary liquidation forms. Now voluntary liquidation forms are introduced so that even the compliance of when there are creditors and when there are no issues, that timelines of 90 and 270 days you have to convene contributories meetings, and with contributories meeting you have to discuss and on the stage of the liquidation what is the status of current status of voluntary liquidation, then you have to extend the time. Otherwise you have to go for immediate distribution within 90 days if there are no creditors, and if there are creditors again it is 270 days. So if it is 90 days you are not able to do the distribution, every 90 days you have to again have, every 90 days cycle you should always have the contributories meeting, and again you have to file the voluntary liquidation forms prescribed under on IBBA platform. So this is again introduction of voluntary liquidation forms, reporting of the status and contributory meetings, all these have to be filed. Then we had amendment in CRP regulations, that is disclose MSME details in the information memorandum. If the company is an MSME, the information memorandum has to contain the complete details of the MSME registration, certification details. Then in February 2025, there was an amendment to CRP regulations in regulation 38.5. Now, as we know, till the resolution
Madam,
plan,
there's no slides for this.
sir, there
No,
was
no.
one slide.
Okay. No, just to clarify, because we don't find any slide being displayed. Okay, fine, fine, fine.
So one more regulation I want to discuss is till the resolution plan approval, we have complete code, we have complete set of regulations, and we have the practices set by the precedents till the resolution plan. After the resolution plan approval, there are a lot of issues which the insolvency professionals, resolution professionals are facing, even the monitoring agents, that is the insolvency professionals who are appointed as monitoring agent for the implementation of the plan. They have been facing issues and they were filing the IAs in the issues regarding the implementation of the plan. So now regulation 38(5) amendment has brought in. Now the IP, the monitoring committee need to file a quarterly progress report with the adjudicating authority on the progress of implementation of the plan. This is a latest amendment. Now we, as a monitoring committee agent, monitoring committee has to file quarterly progress report on the implementation of the plan. And now if RP is appointed as monitor, his fees cannot be more than what he was being paid during the CRP process. So these are the latest amendments in the IBB from the IBBI desk, and we have discussed few evolving jurisprudence and the latest updates. So can we have any questions? I'll just check chat box. So Anjali ma'am, we have any queries? The chat box, we do not have any queries. So any questions for me? Or anyone want to share any of their experiences regarding the topic? Or regarding the latest IBBA amendments or any judicial precedents we can discuss? Can we discuss anything or Anjali ma'am? Anjali ma'am from ICSI IIP.
Anjali ma'am?
Sir, I'm calling Anjali ma'am. Yeah.
Yeah. Hello. Hello.
Hello. Yes, sir. I'm calling ma'am.
Yeah, that's okay. But before she could come, some of the thought process in my mind, which I thought I can share.
Yes, sir.
Now, see, the IBBA has to sit down and make things more easier so
Hmm.
that the timelines can be met. Now, for example, you just take we were discussing about this Bhushan Steel case.
Yes, sir.
Yeah, there you had mentioned about PMLA, right?
Yes, sir.
Yeah. Now, section 71 of PMLA vis-a-vis 238 of IBC.
Hmm.
Each says they are supreme.
Yes.
Now, the lawmakers will have to sit down and try to find a way forward so that the litigation can be reduced. Going to the courts can be reduced, which in turn would reduce the timelines, or the process can happen within the time schedule which they have mentioned, this 180 days or 270 days. All this I think we'll have to put forth before people like y'all. See, you're practicing in a LLP form with an IPE. So
Sir.
I think you people will have to put it across to IBBI so that they take it forward and try to find some sort of sit down and sort out all this. This is my, I mean, this is one example what I gave you between section 71 of PMLA and this 238. Now, when you go ahead, there are a lot of other cases where a lot of ill-gotten assets getting converted, a lot of binami transactions, especially where shell companies, you find a lot of shell companies there which is going into liquidation. I'm talking from the practical perspective. So probably
Yes.
all this would surface in the long run. They'll have to be practical and find a way forward. They'll have to put the Company Secretary Institute should put forth all these things through their central council to the Ministry of Corporate Affairs and find a way forward. This is my personal opinion, madam. I hope you will agree with me. You differ with me. Please come out with your views.
Sir, I completely respect your views for the smooth functioning in the processes. But however, with slightly I'll differ. Since PMLA, it is again related to the tainted money, and the CRP process is again related to the resolution of the corporate debtor. However, the both the objects are different. PMLA, it is different from the IBC. So I'll
Okay.
just share one of my experience in my case. So I was the resolution professional of the Carvi Data Management, where there was an enforcement directorate order against the tainted money, and where the corporate debtor is also one of the party whose assets were attached. But since resolution is the most important object of the code, since the corporate debtor was under IBC, we tried to get an order. See, PMLA, again, the jurisdiction is the PMLA authority, the PMLA courts, or the
Exactly.
High Court with writ. So in
Okay.
our case, what we have done is, since the group had lot of companies, multiple company assets were attached, and here in our case, we had only the business assets. There were no land and buildings. Although other group company had land and buildings, our company had only the financial,
Financial assets.
that is only the business. And
Okay.
this was very important for the resolution of the company in interest of more than 1,000 employees were there in the company. So explaining all these reasons, we went to the High Court and we got the order for going ahead with the resolution plan application to NCLT. So now the PMLA proceedings are continuing against the group companies, against the promoters, and even against the company. But however, now the resolution plan is approved by NCLT and it is being implemented.
No, it is like a chicken and egg story, you know. You can't find a way forward, but ultimately, the people getting affected because of this is the resolution professionals.
Yes, sir.
Unnecessarily, it is getting dragged, and the resolution professionals they incur on the CARP cost, which would take time for them to recover. There's so many other things. I think you should be knowing the practical difficulties.
And
So,
sir, we have Mamta Binani ma'am also, but I'm not sure whether ma'am is available now to share us her experience.
okay.
Anjali ma'am, whether Mamta ma'am is available?
That's for tomorrow, right? Her session is tomorrow or today?
No, sir. Ma'am is different. She is now
Okay.
working as participant. She has
Okay. Okay.
very good experience in handling the ED related issues. In fact, she was one of the first insolvency professionals.
Okay.
So, Mamta, ma'am, are you available? Mamta Binani, ma'am. So again,
No.
it depends on facts to facts, sir. But
Facts and circumstance of each case. I get it. I get it. Okay.
yes, yes, yes,
No, they use all these platforms to drag the case, madam. To
yes.
the RPs are unnecessarily put into stress because of all these, interim people coming and then trying to drag as much as possible.
Yes, agree. But sir, however, as an RP, as a conscious stakeholder of IBC, we have to take an informed and conscious decision of how to handle this ED.
Situation.
Yes.
No,
Each,
no, I appreciate your stand, but again, the point I'm trying to drive here is unnecessarily, litigation is being a thing, and the ease of doing business is hit.
agree, but
Now, take for example the case law you spoken about the EPF.
uh,
Now it is the lethargic attitude coming at the last minute and trying. They said they think they can do anything and everything and get over it. It's very difficult to handle with the officials because their ego is hurting them. You tell them this is not possible, they will not. They're not able to digest that.
sir, in my case, the EPFO 26 crores claims have been admitted, and the SRA is paying that amount. And I am visiting the PF office regularly, and all the employees of the company are complaining against me to IBBI that I am no, I am responsible for not getting the PF amount credited into their account. So IBBI is routing those complaints to me, and the SRA has paid the money and we have remitted into the PF account. Now the PF officials, we are
Okay.
filing the return. They are not reconciling the amounts and remitting into the respective employees' accounts. And we remitted the amount in January. Now today, July, regularly I am visiting the PF office. But
Hmm.
as you rightly said, the integration with other stakeholders, slowly
Yeah,
it is
yeah, I know.
people are understanding, but still there are practical challenges, as you rightly said.
Take some time for things to settle down. Each time, you try to find a way forward, then there's an amendment. It goes on and on and on. Anyway, I thought just to, drag time, I thought
No,
I could discuss this.
sir, these discussions bring more issues and more solution-oriented discussions. So even
Yes, madam. Yes.
IBBA has brought in amendment for the RERA officials to attend the COC meeting.
Yeah, that's a welcome move. That's a welcome move.
So
Yeah.
we've been seeing IBBA is bringing very effective amendments.
Mm.
We should be always vigilant attending various.
Updation. Exactly. Anyway, you've done a good preparation on the case law front, madam. It was very good. It was very, interesting also. And of course, the latest amendment is just an information which you're trying to share with us. Anyway, very interesting session. Thank you. Thank you very much.
Thank you. Thank you very much for initiating the discussion, sir. Hope it was insightful to everyone. And Anjali ma'am, I don't know, sir. I'll try to call.
Probably she's waiting for 5:30 to, Okay, madam. Thank you.
So, Hasmini, can we conclude?
Yes, ma'am. Actually, I was trying to call you. Yes.
Okay. Thank you very much, ma'am,
Thank you.
for such a nice and interactive session.
Yeah.
You have already shared a PPT, ma'am?
I have already shared it with you.
Also.
Thank you,
Okay. Thank you, ma'am.
ICIA, and thank you everyone for your patience hearing. Hope the session was insightful. Thank you.